Hey, folks, welcome back to Are You Smarter Than a Libertarian? The only show where we break down your rights before the government breaks you down. Today, we're diving into the Sixth Amendment. Yeah, the one about criminal trials. Boring? Think again. This is the amendment that stands between you and getting disappeared like you just insulted a king in North Korea. If you know, you know. So, what is part of the Sixth Amendment? Speedy trial, public trial, impartial jury, the right to a lawyer. These are the four most important ones. The right to confront your accusers. That's another hugely important one. The right to call your own witnesses. This sounds pretty basic, right? Like we all know that this is the standard. It should be the standard. But these rights weren't handed to us. They were fought for in the courtroom and on the battlefield. And in this episode, we're going to cover Supreme Court decisions that defined the Sixth Amendment, Founding Fathers' wisdom, and their obsession with jury trials. Which, when we break this down, you'll actually see why the Sixth Amendment is very important. Why this still matters today, especially if you ever find yourself in a courtroom. And we've all been in courtrooms. I've been in courtroom for speeding tickets before. So, let's get started. It's a valid question. So, let's read the text so we can actually figure out what it is. The Sixth Amendment was ratified in 1791, and it reads like a legal force field against tyranny. Also played part into the Fifth Amendment. Now, let's read it. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury, to be informed of the nature and cause of the accusation, to be confronted with witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. That's not just legal jargon. That's a checklist of protections every time the government comes after you. And the government goes after people pretty regularly. The founders were terrified of the British court systems at the time. Secret trials, judges on royal payrolls, no jury of your peers. Go back to my Fifth Amendment video where I talk about the Star Chamber. So the Sixth Amendment became a constitutional seatbelt, and like any seatbelt, you don't think about it until you're headed straight into disaster. You know, like some of the military vehicles that crash into a semi on the highway. Watch that video, it's interesting. The Supreme Court smackdowns. Now, this is where a lot of the rights that we have now have been codified with jurisprudence. All right, let's fast forward to modern times since we were just in 1791. And the Supreme Court has had to remind states that the Sixth Amendment is not optional. Let's hit these highlights. First one is going to be Gideon v. Wainwright, 1963. A guy too poor to afford a lawyer. Florida tells him, tough luck, buddy. The Supreme Court says not so fast. He gets a lawyer. That case gave rise to the public defender system. Now, another case from the Fifth Amendment, Miranda v. Arizona in 1966. Cops interrogated a suspect without telling him his rights. The court ruled you must inform. Hence, you have the right to remain silent. Batson v. Kentucky, 1986. A black defendant, all the black jurors mysteriously removed. The court said that violates both the Sixth Amendment right and the Equal Protection Clause. A jury of your peers. If you're a black person and there are no black juries, that's not a jury of your peers. McCoy v. Louisiana, 2018. The lawyer admitted guilt even though the defendant claimed innocence. The court ruled the defendant controls the defense strategy, not the lawyer. The lawyer wanted an easy out because he probably didn't think he could win the case. Crawford v. Washington, 2004. No more secret testimony. You get to face your accuser, period. These rulings turned the Sixth Amendment from an idea into active protection. Case by case, the court forced the system to honor the Sixth Amendment. The founders' intent, Madison, Hamilton, and the jury. Now we have to go back in time again, but it's important that we understand the full context. Let's go back to the minds who wrote the amendments to the Constitution. James Madison, the architect of the Bill of Rights, proposed the Sixth Amendment in 1789. And here's what he said. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial. That's almost word for word what made it into the Constitution. Madison was addressing fears that the new government might trample on individual rights. Then there's Alexander Hamilton writing in the Federalist number 83. I may do a video about all the Federalist Papers. He argued that jury trials were essential. He even pointed out that both sides in the ratification debate agreed on their value. That kind of agreement was rare back then, but everyone knew that once the government had you in its grips, the jury might be your only protection. Jury nullification. I'll probably do a video on that as well. The Anti-Federalist and the speedy trial problem. Now, see, this is where we get into more of the nuance, like you'll see some trials will take like years to get through. While Hamilton and Madison were polishing their arguments, the Anti-Federalists were lighting their hair on fire. Patrick Henry, who said, "Give me liberty or give me death," also said, "Trial by jury is the best appendage of freedom." He was not exaggerating. Without a public trial and a jury of your peers, the government can arrest you and lock you up indefinitely. And here's the kicker to it all. Even with the Sixth Amendment, some trials take years to happen. And this is one of the cases. In Barker v. Wingo, the court had to define what speedy even means. They came up with a 4-part test. Part 1, how long was the delay? Why was there a delay? Did the defendant ask for a speedy trial? Did the delay hurt the defense? Let's sit on that for a minute. You know who doesn't need a 4-part test to know what speedy means? What do you think? Everybody. Literally everybody else. It's common sense. When we say speedy, we mean speedy. Now you might be going, why does the Sixth Amendment still matter? And that's a valid question for some people. Let's talk about why this still matters. Without the Sixth Amendment, the government becomes the accuser, the judge, and the jury. And in certain cases, the executioner. You get no say, no defense, no chance. Sit in jail for years without trial? Betcha. Prosecutors picking jurors based on race or gender. Accusers who never have to face you in court. That's not justice. That is authoritarianism. The Soviet Union did it with kangaroo courts. So just remember when people talk about jury trials, just go, yeah, the kangaroo courts and the trials in China. The Sixth Amendment is a guardrail, a firewall, a non-negotiable demand that the government play by the rules, and the government will always try to find ways to break the rules, whether it's Republican or Democrat. It is still being tested today. In some courts, and it's just being outright ignored. They're like, man, screw you. The more we understand it, the more we can defend it. Now, we always have a call to action at the end of these podcasts. So let's get into this call to action, and we need to follow through on this. So this wraps up today's episode of Are You Smarter Than a Libertarian? A new one will drop next Monday at 8 a.m. We're not saying the founders were perfect, far from it, but they nailed it on this one. They really did. The Sixth Amendment is a protection you should be ready to use, and use it properly. So talk about it, defend it, know it. In fact, know all your rights. Follow, subscribe, comment, and share this episode with someone who still thinks courtroom drama on TV is how trials really work. I'm Jeff, and as always, stay free, stay informed, stay accountable. I'll see you for the Seventh Amendment next Monday.